Hi, friends! Just recently, I decided to make a little introduction about the dangers of sitting for long periods of time and encourage you to play this audio and do some activities. Walk around, do your chores, and or exercise. But this time, may I just please ask every one of you to sign and share the petition link, which is on the comment below. That simple act in signing said petition will help in getting this plea notice for governments and all concerned governments to resume the search for Gulf Livestock 1 survivors. Thank you so very much. And if you're not yet subscribed, don't forget to hit that subscribe button. We should pick up from the taxability of GOCCs, but before that, let us answer this question. What does lifeblood doctrine dictate regarding the application of these rules in Section 1112? What is the ruling in CIR versus Sunbrook Power Corporation? The lifeblood doctrine dictates that the rules in Section 112 must be applied strictly. Tax refunds are in the nature of tax exemptions, which must be strictly construed against the taxpayer and liberally in favor of the government. This is so because taxes are the lifeblood of the nation. In Camp John Hay Development Corporation versus CBAA, it also appeared in the bar exam. It is about the interplay of the lifeblood theory and another tax remedy, one of the rules under real property taxation. Mentioned therein is the provisions of Section 252 of RA 7160, which is denominated as payment under protest. So when must the payment under protest be lodged? It must be lodged within 30 days from payment of the tax. Explain the rule of payment under protest. Payment under protest means payment of real property tax before filing a protest. So what does the lifeblood doctrine dictate or require regarding the application of Section 252? Before you can protest, you must first pay the real property tax. So what does lifeblood doctrine require regarding the rule of payment under protest? We have to go back because the lifeblood doctrine requires strict compliance of this rule. In short, collection cannot be curtailed by injunction or any like action. Otherwise, the state or the local government unit shall be crippled in dispensing the needed services to the people, and its machinery will gravely be disabled. In the case of CIR versus Pineda, this case enunciates that the Bureau of Internal Revenue has the necessary discretion to avail itself of the most expeditious way to collect taxes because taxes are the lifeblood of the government, and their prompt and certain availability is an imperious need. So, it only means that no one should interfere with the remedy availed of by the BIR to collect taxes because it has that discretion to do so. In that same case, what was the administrative remedy resorted by the BIR, which may in effect bring about speedy collection of taxes? They enforce a tax lien. Enforcing a tax lien is the most expeditious way to collect taxes, and this administrative remedy may not require judicial proceedings. What is the principle of strictissimi juris? This principle states that tax exemptions are strictly construed against the taxpayer and liberally construed in favor of the government. This principle was applied in Davao Gulf Lumber Corporation versus CIR. In that case, it says that tax exemption should be construed strictissimi juris against the grantee. Equity is not a ground for tax exemption. A claim of exemption from tax payments must be clearly shown and based on language in the law too plain to be mistaken. That is Section 5 RA 1435 as a tax exemption must be construed strictissimi juris against the grantee. According to an eminent authority on taxation, there is no tax exemption solely on the ground of equity. The exemptions to the principle of strictissimi juris are 1. When the law expressly provides for liberal interpretation or construction of tax exemptions. 2. When the grantee of tax exemption is a religious or a charitable institution. 3. When the grantee of tax exemption is the government, its political subdivision, or instrumentalities. And 4th, when the taxpayer falls within the purview of exemption by clear legislative intent. And 5, when the grantee is a municipal corporation with respect to its public property only. And 6, when the imposition is special taxes relating to special cases and affecting only special classes of persons. All right, back to taxability of GOCC. GOCCs perform propriety functions, hence, they are subject to taxation. However, certain corporations have been granted exceptions under Section 27, letter C of RA 8424 as amended by RA 9337, which took effect on July 1st, 2005 to 8. Government Service Insurance System or GSIS, Social Security System SSS, and Philippine Health Insurance Corporation PHIC, and finally Philippine Charity Sweepstakes Office or PCSO. What is constitutional limitations? Taxation, being inherent in sovereignty, need not be clothed with any constitutional authority for it to be exercised by the sovereign state. Instead, constitutional provisions are meant and intended more to regulate and define rather than to grant the power emanating therefrom. What are the provisions directly affecting taxation? 1. Prohibition against imprisonment for non-payment of poll tax. Basis: no person shall be imprisoned for debt or non-payment of poll tax. Article 3, Section 20. A poll tax is one levied on persons who are residents within the territory of the taxing authority without regard to their property, business, or occupation. Thus, only the basic community tax under the LGC could qualify as a poll tax, and the non-payment of other additional taxes imposed, not being in the nature of poll taxes, may validly be subjected by law to imprisonment. In other words, while a person may not be imprisoned for non-payment of a cedula or poll tax, he may be imprisoned for non-payment of other kinds of taxes where the law so expressly provides. 2. Uniformity and equality of taxation. The basis is the rule of taxation shall be uniform and equitable. The Congress shall evolve a progressive system of taxation. That is Article 6, Section 28, number 1. Now explain the following concepts in taxation. Uniformity. It means that all taxable articles or kinds of property of the same class shall be taxed at the same rate. A tax is considered uniform when it operates with the same force and effect in every place where the subject is found. Different articles may be taxed at different amounts, provided that the rate is uniform on the same class everywhere, with all people at all times. Equitability. Taxation is said to be equitable when its burden falls on those better able to pay. Equality. It is accomplished when the burden of the tax falls equally and impartially upon all the persons and property subject to it. Explain the requirement of uniformity as a limitation in the imposition and or collection of taxes. Uniformity as the imposition and or collection of taxes means that all taxable articles or kinds of property of the same class shall be taxed at the same rate. The requirement of uniformity is complied with when the tax operates with the same force and effect in every place where the subject of it is found. Churchill in Tite v. Concepcion, 34 Phil. 969. Different articles may be taxed at different amounts provided the rate is uniform on the same class everywhere, with all people at all times. Accordingly, singling out one particular class for taxation purposes does not infringe the requirement of uniformity. A law was passed exempting doctors and lawyers from the operation of the value-added tax. Other professionals complained and filed a suit questioning the law for being discriminatory and violative of the Equal Protection Clause of the Constitution, since complainants were not given the same exemption. Is the suit meritorious or not? Yes, the suit is meritorious. The VAT is designed for economic efficiency. Hence, should be neutral to those who belong to the same class. Professionals are a class of taxpayers by themselves who, in compliance with the rule of equality of taxation, must be treated alike for tax purposes. Exempting lawyers and doctors from a burden to which other professionals are subjected will make the law discriminatory and violative of the Equal Protection Clause of the Constitution. While singling out a class for taxation purposes will not infringe upon this constitutional limitation, Shell versus Vano 94 Field 389, singling out a taxpayer from a class will no doubt transgress the constitutional limitation. Ormoc Sugar Company versus Treasurer of Ormoc City 22 SCRA 603. Treating doctors and lawyers as a different class of professionals will not comply with the requirements of a reasonable, hence valid classification because the classification is not based upon substantial distinction, which makes real differences. The classification does not comply with the requirement that it should be germane to the purpose of the law either. This is Pepsi Cola Bottling Company versus City of Butuan. Heeding the pronouncement of the President that the worsening traffic condition in the metropolis was a sign of economic progress, the Congress enacted Republic Act 1071, also known as an act imposing a transport tax on the purchase of private vehicles. Under RA 1071, buyers of private vehicles are required to pay a transport tax equivalent to 5% of the total purchase price per vehicle purchased. RA 1071 provides that the Land Transportation Office or LTO shall not accept for registration any new vehicles without proof of payment of the 5% transport tax. RA 1071 further provided that existing owners of private vehicles shall be required to pay a tax equivalent to 5% of the current fair market value of every vehicle registered with the LTO. However, RA 1071 exempts owners of public utility vehicles and the government from the coverage of the 5% transport tax. A group of private vehicle owners sue on the ground that the law is unconstitutional for contravening the Equal Protection Clause of the Constitution. Rule on the constitutionality and validity of RA 1071. RA 10701 is valid and constitutional. A levy of tax is not unconstitutional because it is not intrinsically equal and uniform in its operation. The uniformity rule does not prohibit classification for purposes of taxation. British American Tobacco versus Jose Isidro. GR 163583. Uniformity in taxation, like the kindred concept of equal protection, merely requires that all subjects or objects of taxation similarly situated are to be treated alike both in privileges and liabilities. Uniformity does not forfend classification as long as 1. The standards that are used therefore are substantial and not arbitrary. 2. The categorization is germane to achieve the legislative purpose. And 3. The law applies, all things being equal, to both present and future conditions. And finally, the classification applies equally well to all those belonging to the same class. Rufino Tan versus Ramon del Rosario, GR 109289. All of the foregoing requirements of a valid classification having been met, and those which are singled out are a class in themselves, there is no violation of the Equal Protection Clause of the Constitution. So, how about the 20 sales discount for senior citizens and persons with disabilities? Does it violate the constitutional right of equal protection? No. The Equal Protection Clause is not infringed by legislation which applies only to those falling within a specified class. If the groupings are characterized by substantial distinctions that make real differences, one class may be treated and regulated differently from another. Southern Luzon Drug Corporation versus DSWD. GR 199669, April 25, 2017. What is progressive taxation? Taxation is progressive when tax rate increases as the income of the taxpayer increases. It is based on the principle that those who are able to pay more should shoulder the bigger portion of the tax burden. Does the Constitution prohibit regressive taxes? No. The Constitution does not really prohibit the imposition of regressive taxes. What it simply provides is that Congress shall evolve a progressive system of taxation. Meaning of evolve as used in the Constitution is the constitutional provision has been interpreted to mean simply that direct taxes are to be preferred as much as possible. Indirect taxes should be minimized. The mandate of Congress is not to prescribe but to evolve a progressive tax system. This is a mere directive upon Congress, not a justifiable right or a legally enforceable one. We cannot avoid regressive taxes but only minimize them. Tolentino et al. Versus Secretary of Finance, GR number 115455. How about VAT? Is it regressive? Yes. The principle of progressive taxation has no relation with the VAT system inasmuch as the VAT paid by the consumer or business for every goods bought or services enjoyed is the same regardless of income. In other words, the VAT paid eats the same portion of an income, whether big or small. The disparity lies in the income earned by a person or profit margin marked by a business, such that the higher the income or profit margin, the smaller the portion of the income or profit that is eaten by the VAT. Conversely, the lower the income or profit margin, the bigger the part that the VAT eats away. At the end of the day, it is really the lower income group or businesses with low profit margins that is always hardest hit. Abacada Guro versus Ermita, GR 168058. Next is the grant by Congress of authority to the President to impose tariff rates. Basis: the Congress, made by law, authorized the President to fix within specified limits and subject to such limitations and restrictions that it may impose tariff rates, import and export quotas, tonnage and wharfage dues, and other duties or imposts within the framework of the National Development Program of the government, and that is Article 6, Section 28. Flexible Tariff Clause. This clause provides the authority given to the President to adjust tariff rates under Section 401 of the Tariff and Customs Code, now Section 1608 of RA 10863, known as Customs Modernization and Tariff Act, CMTA of 2016. Garcia versus Executive Secretary, DR 10-1273, July 3, 1992. This authority, however, is subject to limitations and restrictions indicated within the law itself. So, what are the requisites on the authority of the President to impose tax? Now, before we continue that, let's answer these questions. Is GSIS an instrumentality or GOCC? Yes. GSIS is the government instrumentality. Why does the principle of strictissimi juris not applicable to government, its political subdivision or instrumentalities? It is because it will result in the absurd situation of the government taking money from one pocket and putting it in another. When do you apply this rule? The tax exemption is the general rule and taxation is the exemption. The general rule is that taxation is the rule and exemption is the exception. It shall apply when the grantee is a municipal corporation and the property is not held in private ownership but a public property. What is the jurisprudential ruling of the court in Ferdinand Marcos II versus Court of Appeals? The court ruled therein that the approval of the court sitting in probate or as a settlement tribunal over the deceased estate is not a mandatory requirement in the collection of estate taxes. Why? The collection of taxes does not necessitate the approval of the probate court because taxes are the lifeblood of the government and should be collected without unnecessary hindrance. To require the approval of the probate court is a cause of delay to the collection of taxes. Is there a provision that before the BIR can collect taxes, there must be an approval of the probate court? No, there is none. Is there a revenue regulation to that effect? No, there is not. May the taxes be the subject of set-off or compensation? No, taxes may not be the subject of set-off or compensation because 1. Taxes are not ordinary obligations which may be governed by the Civil Code. 2. Taxes are not based on a contract, debt, or judgment, but on legal impositions. And 3. The government and the taxpayer are not creditors and debtors of each other. In the case of Felix Mining Corporation versus CIR, it is about set-off of taxes. The ruling of the court in that case is the court did not allow the set-off of taxes. The lifeblood doctrine disfavors the set-off of taxes because it will reduce tax collection and there will be less revenue for the government. Is there an exception to this rule? Yes. There is the case of Domingo versus Garlitos. The peculiar circumstance therein is the enactment of R.A. 2700, appropriating certain amount of money for the taxpayer's claim that made such claim due and demandable or liquidated. Thus, the court allowed compensation. In YMCA versus CIR, also came out in the bar exams, YMCA claimed that as a non-stock, non-profit organization, it should be exempt from income taxation with regard to the profits on leasing its facilities to non-exempt entities. Well, the court ruled that YMCA is taxable on its rental income. The exemption provided in Section 30, letter E of the NIRC must be strictly construed against YMCA. Moreover, it is taxable because the tax code provides that the income of charitable organizations, such as YMCA, from any of their properties, real or personal, or from any of their activities conducted for profit, regardless of the disposition made of such income, shall be subject to tax. Now, going back on the requisites on the authority of the President in imposing tax. 1. Delegated by Congress through a law. The authorization granted to the President must be embodied in a law. Hence, the justification cannot be supplied simply by inherent executive powers. It is Congress which authorizes the President to impose tariff rates, import and export quotas, tonnage and wharfage dues, and other duties or imposts. Thus, the authority cannot come from the Finance Department, the National Economic Development Authority, or the World Trade Organization. No matter how insistent or persistent these bodies may be, Southern Cross Cement Corporation versus Cement Manufacturers Association of the Philippines, GR 158540, August 3, 2005, reiterated that fact. Subject to congressional limits and restrictions, the authorization to the President can be exercised only within the specified limits set in law and in further subject to limitations and restrictions which Congress may impose. Consequently, if Congress specifies that the tariff rates should not exceed a given amount, the President cannot impose a tariff rate that exceeds such amount. Assuming there is a conflict between the specific limitation in the Constitution and the general executive power of control and supervision, the former prevails in the specific instance of safeguard measures such as tariffs and imposts, and would thus serve to qualify the general grant to the President of the power to exercise control and supervision over his or her subalterns. Southern Cross Cement versus Cement Manufacturer, the same, GR 158540. And lastly, within the framework of National Development Program. Now, what is the prohibition against taxation of religious, charitable entities and educational entities? The basis is charitable institutions, churches and personages, or convents appertinent thereto, mosques, nonprofit cemeteries, and all lands, buildings, and improvements actually, directly, and exclusively used for religious, charitable, or educational purposes shall be exempt from taxation. Article 6, Section 28, Number 3. It covers all real property taxes only. Accordingly, a conveyance of such exempt property can be subject to transfer taxes. Property is exempt under the Constitution from the payment of property taxes. These are charitable institutions, churches, and parsonages or convents appertinent thereto, mosques, 4. Nonprofit cemeteries, 5. All lands, buildings, and improvements actually, directly and exclusively used for religious, charitable, or educational purposes shall be exempt from taxation. What does charitable mean? It is not restricted to relief of the poor or sick. The test whether an enterprise is charitable or not is whether it exists to carry out a purpose recognized in law as charitable or whether it is maintained for gain, profit, or private advantage. Lung Center of the Philippines versus Quezon City, Tier 144, 104. Also, an organization must meet the substantive test of charity. Charity is essentially a gift to an indefinite number of persons which lessens the burden of government. In other words, charitable institutions provide for free goods and services to the public, which would otherwise fall on the shoulders of government. CIR versus St. Luke's Medical Center, GR 195909. So, what does actual, direct, and exclusive use of the property for religious, charitable, and educational purposes mean? It is the direct and immediate and actual application of the property itself to the purposes for which the charitable institution is organized. It is not the use of the income from the real property that is determinative of whether the property is used for tax exempt purposes. In the case of Lung Center of the Philippines versus City Assessor of Quezon City, the court ruled that under the 1987 Constitution, for lands, buildings, and improvements of the charitable institution to be considered exempt, the same should not only be exclusively used for charitable purposes. It is required that such property be used actually and directly for such purposes. Exclusive is defined as possessed and enjoyed to the exclusion of others, debarred from participation or enjoyment, and exclusively is defined in a manner to exclude as enjoying a privilege exclusively. If real property is used for one or more commercial purposes, it is not exclusively used for the exempted purposes, but is subject to taxation. The words dominant use or principal use cannot be substituted for the words used exclusively without doing violence to the Constitution and the law. In sum, the court ruled that the portions of the land leased to private entities as well as those parts of the hospital leased to private individuals are not exempt from taxes. What are the rules on taxation of non-stock corporations for charitable and religious purposes? For purposes of income taxation, the income of non-stock corporations operating exclusively for charitable and religious purposes, no part of which inures to the benefit of any member, organizer, or officer of any specific person, shall be exempt from tax. However, the income of whether kind and nature from of their properties, real or personal, or from any of their activities for profit, regardless of the disposition made of such income, shall be subject to tax. Section 30, letter E, and last paragraph. And this is actually the paragraph that the court used in the case of YMCA versus CIR. Note: an organization may be considered as nonprofit if it does not distribute any parts of its income to stockholders or members. However, despite its being a tax-exempt institution, any income such institution earns from activities conducted for profit is taxable, as expressly provided in the last paragraph of Section 30, CIR versus St. Luke's Medical Center, GR 195909. Donations received by religious, charitable, and educational institutions are considered as income but not taxable income as they are items of exclusion. On the part of the donor, such donations are deductible expense provided that no part of the income of which inures to the benefit of any private stockholder or individual in an amount not exceeding 10% in case of individual and 5% in case of a corporation of the taxpayer's taxable income derived from trade or business or profession, Section 34, letter H. For purposes of donors and estate taxation, donations in favor of religious and charitable institutions are generally not subject to tax, provided, however, that not more than 30% of the said bequests, devices, or legacies or transfers shall be used by such institutions for administration purposes. Sections 87, letter D, and Section 101 NIRC. Illustration: in 1991, Imelda gave her parents a Christmas gift of 100,000 and a donation of 80,000 to the parish church. She also donated a parcel of land for the construction of a building to the PUP Alumni Association, a non-stock nonprofit organization. Portions of the building shall be leased to generate income for the association. Question: is the Christmas gift of 100,000 to Imelda's parents subject to tax? How about the donation to the parish church? And how about the donation to the PUP Alumni Association? And this was answered in the 1994 bar. The Christmas gift of 100,000 given by Imelda to her parents is not taxable because under the law, Section 99, letter A of NIRC, net gifts not exceeding 100,000 are exempt. Letter B, the donation of 80,000 to the parish church even is tax exempt provided that not more than 30% of the said bequests shall be used by such institutions for administration purposes. That is Section 101, letter A and 3. The donation to the PUP Alumni Association does not also qualify for exemption, both under the Constitution and the aforecited law, because it is not an educational or research organization, corporation, institution, foundation, or trust. Another, the Constitution exempts from taxation charitable institutions, churches, personages, or convents appertinent thereto, mosques, and nonprofit cemeteries and lands, buildings, and improvements actually directly and exclusively used for religious, charitable, or educational purposes. Mercy Hospital is a 100-bed hospital organized for charity patients. Can said hospital claim exemption from taxation under the provision? Yes, Mercy Hospital can claim exemption from taxation under the provision of the Constitution, but only with respect to real property taxes, provided that such real properties are used actually, directly, and exclusively for charitable purposes. Illustration: De La Salle University leases out a portion of its property to private concessionaires, that is, commercial canteens and bookstore. The lease payments were factually proven to be used for educational purposes. Questions: is the land owned by De La Salle University subject to real property tax? Yes. The leased portion of the building may be subject to real property tax. The test of exemption from taxation is the use of the property for purposes mentioned in the Constitution. The lease of a portion of a school building for commercial purposes removes such asset from the property tax exemption granted under the Constitution. There is no exemption because the asset is not used actually, directly, and exclusively for educational purposes. The commercial use of the property is also not incidental to and reasonably necessary for the accomplishment of the main purpose of a university, which is to educate its students. Abra Valley College versus Aquino, 254 Phil 83. It is also cited in CIR versus De La Salle University, GR 196596, November 9, 2016. Are the lease payments received by De La Salle University subject to income tax? And C, are the lease payments received by De La Salle University subject to VAT? Answer to letter B and C. No. If the university actually directly and exclusively uses for educational purposes the revenues earned from the lease of its school building, such revenues shall be exempt from taxes and duties. The tax exemption no longer hinges on the use of the asset from which the revenues were earned, but on the actual, direct, and exclusive use of the revenues for educational purposes. To avail of the exemption, the taxpayer must factually prove that it is used actually, directly, and exclusively for educational purposes, the revenues or income sought to be exempted. In sum, the crucial point of inquiry then is on the use of the asset or on the use of the revenues. These are two things that must be viewed and treated separately. CIR versus De La Salle University, GR 196596. Now, what are donors' tax, state tax, VAT, and other taxes? Article 14, Section 4, Number 4, which provides that all grants, endowments, donations, or contributions used actually, directly, and exclusively for educational purposes shall be exempt from tax. It is not self executing as it requires legislative enactment providing certain conditions for exemption. However, since Section 101, letter A and number 3 of NIRC under donor's tax declared its exemption, then these donations are tax exempt. Under the state tax, non-stock, non-profit educational institutions are not included under the exempt transfers mortis causa, hence they are not tax exempt. Pursuant to Section 109, letter M, private educational institutions shall be exempt from VAT, provided they are accredited as such either by DepEd or CHED. However, this does not extend to other activities involving the sale of goods and services. However, they shall be subject to internal revenue taxes on income from trade, business, or other activity, the conduct of which is not related to the exercise or performance of their educational purposes or functions. Under Article 14, Section 4, Number 3 of the 1987 Constitution, all revenues and assets of non-stock, non-profit educational institutions used actually, directly, and exclusively for educational purposes are exempt from taxes and duties. Our income derived from dormitories, canteens, and bookstores, as well as interest income on bank deposits and yields from deposits substitute automatically exempt from taxation? No. The interest income on bank deposits and yields from deposit substitutes are not automatically exempt from taxation. There must be a showing that the incomes are used actually, directly, and exclusively for educational purposes. The income derived from dormitories, canteens, and bookstores are not also automatically exempt from taxation. There is still a requirement for evidence to show actual, direct, and exclusive use for educational purposes. The 1987 Constitution does not distinguish with respect to the source or origin of the income. The distinction is with respect to the use which should be actual, direct, and exclusive for educational purposes. Where the Constitution does not distinguish with respect to source or origin, the NIRC should not make distinction too, said Mamalateo, 2008. Okay, let's review again stages, aspects, and phases of taxation. Explain the stages or aspects of taxation. These aspects do not refer to the fundamental principles of taxation. We use the acronym LAP, LAP. 1. Levy or imposition, which refers to the enactment of tax laws. 2. Assessment and collection, which provides for the implementation, enforcement, or administration of tax laws. And P. Payment, which is defined as the compliance by the taxpayer. What is again the nature of levy or imposition? It is legislative in nature. And what is the nature of assessment and collection? They are administrative in nature. How about the technical term for levy or imposition? It is the impact of taxation. What is the technical term for payment? It is the incidence of taxation. How is assessment under the Internal Revenue Taxation? In Adamson versus Court of Appeals, assessment under the Internal Revenue Taxation is defined as the written notice and demand made by the BIR on the taxpayer for the settlement of a tax due liability that is definite, final, and fixed. And the Supreme Court ruled on this case that the recommendation letter of the commissioner cannot be considered a formal assessment as it was not addressed to the taxpayers. B. There was no demand made on the taxpayer to pay the tax liability, nor a period for payment set therein. And C. The letter was never mailed or sent to the taxpayer by the commissioner. It was only an affidavit of the computation of the alleged liabilities and thus merely served as prima facie basis for filing criminal information. Now the question is the letter of the BIR to the taxpayer qualified? No, because the assessment must contain final assessment or determination. So what is assessment in real property taxation? Assessment under real property taxation is the act or process of determining the value of a property or proportion thereof subject to tax, including the discovery, listing, classification, and appraisal of properties. What are the requisites of conditions for a valid assessment of real property tax? There are five requisites. In Meralco versus Norvalis, the Supreme Court enumerated the following guidelines. We use the acronym CALMA, KALMA. 1. The assessment must contain the K, kind of property. It must set forth the A, assessed value of the real property. It must indicate the L, level of assessment. It must specify the fair market value of the property. So where is the M there? Market value of the property. And A, it must clearly indicate the actual use of property. So actual use of property, market value of property, level of assessment, assessed value of the real property, and the kind of property. What is assessment in customs law? In Filipinas Shell Petroleum Corporation versus Commissioner of Customs, the Supreme Court ruled that assessment in customs law is known as liquidation. It refers to the final computation and ascertainment of the collector of duties on imported merchandise based on official reports as to the quantity, character, and value thereof, and the collector's finding of the applicable rate of duty. Taxation as inherent power of the state. Why is the power to tax inherent in the sovereign state? By the way, let's go back to one of the questions asked in the case of Adamson versus CA. Must a criminal prosecution for tax evasion be preceded by a deficiency tax assessment? The answer is yes. When fraudulent tax returns are involved, as in the case of Adamson versus CA, a proceeding in court after the collection of such tax may be begun without assessment, considering that upon investigation of the examiners of the BIR, there was a preliminary finding of gross discrepancy in the computation of the capital gains taxes due from the transactions. The tax code is clear that the remedies may proceed simultaneously. Oh, so does the CDA have jurisdiction on the case? Unfortunately, no. While the laws governing CTA have expanded the jurisdiction of the court, they did not change the jurisdiction of the CDA to entertain an appeal only from a final decision of the commissioner, or in cases of inaction within the prescribed period. Since in the cases of Barr, Adamson versus CA, the commissioner has not issued an assessment of the tax liability of the petitioner. Therefore, the CTA has no jurisdiction. So why is the power to tax inherent in the sovereign state? It is considered inherent in a sovereign state because it is a necessary attribute of sovereignty. Without this power, no sovereign state can exist nor endure. The power to tax proceeds upon the theory that the existence of a government is a necessity, and this power is an essential and inherent attribute of sovereignty, belonging as a matter of right to every independent state or government. No sovereign state can continue to exist without the means to pay its expenses, and that for those means it has the right to compel all citizens and property within its limits to contribute, hence the emergence of the power to tax. Explain the twofold nature of taxation. This is a very interesting question. Let's memorize it. Taxation is an 1. Inherent attribute of sovereignty, and it is also 2. Legislative in character. Such power is exclusively vested in the Congress. This is based upon the principle that taxes are a grant of the people who are taxed, and the grant must be made by the immediate representatives of the people. And where the people have laid the power, there it must remain and be exercised. Taxation is an inherent attribute of sovereignty, and it is also legislative in character. Such power is exclusively vested in the Congress. This is based upon the principle that taxes are a grant of the people who are taxed, and the grant must be made by the immediate representatives of the people. And where the people have laid the power, there it must remain and be exercised. Non-delegations of power. The power to tax is exclusively vested in the legislative power. What are the exemptions to the principle of non-delegation of powers? If you have forgotten the exemptions, go back and listen to it again from the beginning. The famous statement, power to tax is the power to destroy, reconcile these seemingly conflicting views. Chief Justice Marshall opines that the power to tax is the power to destroy. Justice Malcolm opines that the power to tax does not include the power to destroy. The conflict is more apparent than real. Chief Justice Marshall is correct in the sense that the power to tax is the power to destroy if it is used validly as an implement of the police power of the state. Justice Malcolm is likewise correct in this perspective, where the power to tax is used solely for the purpose of raising revenues. It cannot be allowed to confiscate or destroy. From Justice Isagani Cruz. What is the meaning of the phrase, the conflict is more apparent than real? It means that there is no real conflict here. What does this mean? The power to tax is not the power to destroy so long as the Supreme Court sits. In the case of Season versus Ancheta, the Supreme Court held that while taxation is said to be the power to destroy, it is by no means unlimited. If so great an abuse is manifested as to destroy natural and fundamental rights which no free government could consistently violate, it is the duty of the judiciary to hold such an act unconstitutional. The Constitution, as the fundamental law of the land, overrides any legislative or executive act that runs counter to it. In any sense, therefore, where it can be demonstrated that the challenged statutory provision fails to abide by its command, then the court must so declare and adjudge it null. Justice Malcolm stresses that taxation is the strongest of all the powers of the government. What does that mean? The police power of the state is supreme under the principle of salus populi est suprema lex. The power of eminent domain is supreme under the concept of expropriation. Taxation, thus, although referred to as the strongest of all the powers of the government, cannot be interpreted to mean that it is superior to the other inherent powers of the government. It is supreme insofar as the selection of the subject of taxation is concerned. Is market stall fee a license or a tax? The market stall fees are considered as license because the objective of imposing market stall fees is regulation and not revenue generation. Tax is imposed in the exercise of police power, primarily for purposes of regulation, while the latter is imposed under the taxing power primarily for purposes of raising revenues. Thus, if the generating of revenue is the primary purpose and regulation is merely incidental, the imposition is a tax. But if regulation is the primary purpose, the fact that incidentally revenue is also obtained does not make the imposition a tax. So what is the reason behind this ruling? Tax is imposed in the exercise of police power, primarily for purposes of regulation, while the latter is imposed under the taxing power, primarily for purposes of raising revenue. Thus, if the generating of revenue is the primary purpose and regulation is merely incidental, the imposition is a tax. But if the regulation is the primary purpose, the fact that incidentally revenue is also obtained does not make the imposition a tax. Just repeat it. Now, what are the distinctions between a license and a tax? The distinction between a license and a tax are as follows. As to the exercise of power, a tax is levied in the exercise of the taxing power, while license fees emanate from the police power of the state. As to purpose, the primary purpose of taxation is to generate revenues, while license fees are imposed primarily for regulation. As to subject, the subject of taxation is persons, properties, activities, while the subject of license is limited to the right to engage in a business or activity. As to consequence, in case of non-payment, failure to pay tax makes you business illegal, while failure to pay your license fee does not have that effect, as it is merely a regulatory fee. In the Imperial Law, Electric Power Industry Reform Act of 2001, called the Universal Charge, the Supreme Court held that the universal charge is a license fee. It is imposed and can be amply discerned as regulatory in character because in the imperial law that states police power, particularly its regulatory dimension, is invoked. How about the Coco Levy Fund as a tax or license? Is it a regulatory imposition of tax? Now, that is a tax. In Cojuangco Jr. versus Republic, the court ruled that the Coco Levy funds are taxes since the purpose of its imposition is to raise revenue for the rehabilitation of the coconut industry. How about the building permit? Is it a fee or a tax or a license? It is a regulatory fee. Why is a building permit a regulatory fee? That is a building permit fee as a regulatory imposition is highlighted in the fact that in proposing an application for a building permit, the building official shall see to it that the applicant satisfies and conforms to the approved standard requirement on zoning and land use, lines and grades, structural design, sanitary and sewerage, environmental health, electrical and mechanical safety. Clearances from various government authorities exercising and enforcing regulatory functions affecting building structures may be required before a building permit may be issued. So, how about the socialized housing tax? Is it a tax or a regulatory fee? It is not a tax imposed by the local government, but it is a license or regulatory fee. Its name is a bit misleading. What is the reason behind this ruling? It is levied with a regulatory purpose. The levy is primarily in the exercise of the police power for the general welfare of the entire city. It is greatly imbued with public interest. Removing some areas in Quezon City is not only beneficial to the underprivileged and homeless constituents, but advantageous to the real property owners as well. The situation will improve the value of their property investments, fully enjoying the same in view of an orderly, secure, and safe community, and will enhance the quality of life of the poor, making them law abiding constituents and better consumers of business products. On the definition of public purpose, the Supreme Court ruled that the term public purpose is not defined. It is an elastic concept that can be hammered to fit modern standards. It should be given a broad interpretation. So, what is the test to determine if the purpose is for public? Is it the number of persons benefited? Public may refer to a special group of persons. The senior citizens are a special group of persons who have contributed to the general welfare and common good of the nation in the prime of their lives. Let's pick up from page 22 on our golden notes on our next upload. Thanks.